Thank you, Orla. And I think I've 8 minutes. And I welcome the opportunity to say something on this bill. And I want to deplore the fact and the manner in which it's been done. This is based on a bill that was brought in December with no pre-legislative scrutiny, no learning, and no indication that we'd be back here again in March looking to pass emergency legislation. When the 22 Act was passed, the title set out it was an act to provide for emergency measures, and it went on to say because of the exceptional circumstances that have arisen in the market for that supply. The exceptional circumstances in the market, and further because of the situation in the Ukraine. And I fully understand that the Ukraine has had detrimental consequences, but it was primarily because of the market and the failure of the market and what was going on. And that statement tells me that we've utterly failed to learn. And I'm going to go around to the Aarhus Convention and the lip service being paid to it in a minute. But back in 2019, we were forced, screaming and shouting, to declare a climate change emergency and a biodiversity emergency, 2021, almost 4 years ago, and no parallel action in relation to energy that's sustainable. And here we are with emergency legislation, which absolutely bypasses the Planning Act. The Planning Act of 2000 as amended, and it's clearly set out that we're completely and utterly bypassing that, with no pre-legislative scrutiny, no digest from the library, no analysis of how this situation has arisen other than the market and the market failure, and yet we're proceeding with a system that's utterly reliant on the market, utter consumption on a constant basis without any questioning. One of the eye-opening reports for me was the data centre report, the government policy endorsing it and thumbs up going back to 2018 without a single attempt to analyse what data centres were doing to our environment. Of course we need them, but we need analysis in relation to them and the use of electricity. And here we are today now, completely bypassing planning legislation, utterly bypassing it, in a country where we've declared a climate emergency, to allow for emergency generation of electricity through diesel. And while I will end up probably supporting this legislation because nobody wants blackouts in winter, I utterly deplore the manner in which we've been led by the nose to this point, without any sunset clause in this legislation, and Deputy Naughton, fair play to him, has brought in an amendment. So we have an open-ended emergency now. An open-ended emergency with electricity generation based on diesel to avoid blackouts while not dealing with the huge consumption by data centres and others. No regulations laid down for them. And then we have this type of data centre report in the paper. We have Microsoft, Amazon and Google seeking to expedite applications to the EPA for industrial emissions licences. And this is a press report. And we're told how worried they are because they have licences, applications in, and the EPA apparently are very tardy. Not a single government spokesperson has mentioned whether the EPA need extra help to cope with the workload or what's going to happen in relation to that. But what I find extraordinary altogether is a spokesperson for the EPA said the agency was assessing 16 requests for industrial emission licences from data centre operators alone, 16 requests. And then down at the bottom, a spokesperson for the Department of Enterprise described the engagement between Coveney and Cloud Infrastructure, the representative group, as a good meeting. So, the good meeting. Coveney, she said, Coveney had informed the companies that matters relating to mandatory demand curtailment and industrial emission licences applications are for EirGrid and the EPA. So that's the statement that Coveney is making. It's for EirGrid and the EPA, not for him. So what was the purpose of the meeting? That meeting should have been over in 2 minutes, shouldn't it, if that's the statement? It's not a matter for me, it's not a matter for government, it's a matter for EirGrid and it's a matter for the EPA. But yet it was described as a very good meeting. And you see, my difficulty is, and the difficulty for the people I represent is, we have huge problems with trust because language is turned on its head. So we look at this piece of legislation that's ignoring planning legislation and making a mockery of the Aarhus Convention, a quarter of a century after we signed up to it, and 2012 we ratified it. It took us from 98 to 2012 to ratify it. And the three pillars was access to information, access to decision making, and access to justice. All gone by the board. And we're being told that the EPA will make available a copy of the alternative assessment. You now have introduced a parallel system to the planning law to suit an emergency that shouldn't have been an emergency because it should have been planned for. And if I go with you that emergencies come up and we have to be realistic in the world, I go with you on that argument. If you put your hands up and say, we're only doing it for a specific period of time, and we're only doing it because successive governments have utterly failed to plan properly in relation to renewable energy. And the same model for the energy for the future and the hands up to wind farms and windmills on the sea and on land, without any overall picture as to how the communities are going to benefit, how the communities get ownership, how we get the communities to buy in. And all the time, Minister, just last week I pointed out to you that an application for a decarbonisation zone in Galway has set in your department since it was set in 2 years ago. And you sought to criticise the local authorities, which I'm very guilty of myself on occasions, and I hope rightly so. But on this occasion, they're on the side of the angels. They submitted their application for a decarbonisation zone over 2 years ago, and nothing has happened. They're still waiting on directions. That's just one practical example. A mitigation plan was brought in, not by yourselves, that was found to be vague and quashed by the Supreme Court or the High Court and Friends of the Environment. And all of the time, a certain type of narrative that there are too many objectors when we really are utterly reliant on them to protect our environment. And what you're doing here is absolutely cutting the ground from under the protection of the environment without any time clause, without any recognition that this is just unacceptable. And if it has to be acceptable, then let it be for a short period of time and a sunset clause. Nothing like that is here. Absolutely nothing. And the legislation itself is difficult to understand, and you might clarify in terms of, I think it was rushed. And on page 6, amendment section 7, 2, the title is Agency to take alternative assessment into account. And then paragraph 2, the agency may make any feature of the project or measure envisaged to avoid, prevent, reduce, or I don't know what that means. I think I know what you're trying to say, but it's been done in such a rush, it doesn't make sense. It's not plain English, and it's not understandable. So if I'm vote for this, and the jury is out so far in my head on whether I will or not, I will do it most reluctantly because an emergency has been allowed to develop which should have been avoided. And with this type of legislation, we need pre-legislative scrutiny, but equally importantly, we need a range of actions that tells me you're serious about energy and renewable energy and being owned by the people. Because if we've learned anything, it's bigger does not work. We need transformative action, and this is not what we're getting. Thank you.